All right, well, thank you everyone for joining and do quick introduction here. So I'm Shane from 10 Capital. I run the events. We have a great event for you today about obtaining patents and protecting your intellectual property. We have Pete Thurlow here with us from Polsinelli and Hall from 10 Capital as well. And with that, Hall, do you want to take the reins?
Great. Thanks, Shane. And Pete, thanks for joining us here today. I want to thank our audience, those who came to join us as well. This will be interactive. So as we go along, if you have questions, go ahead and put them in and we'll answer them. But, intellectual property is a key aspect of any startup. I would say half the value of a patent to a business is in raising funding. And so before you go out to raise funding, it's important to go ahead and file those patents or come up with your intellectual property strategy and make that a part of your pitch deck as well. And to talk to us about the latest version of what's going on in the IP world is Pete Thurlow. Pete, thanks for joining us.
Hey, all. Thank you very much. It's nice to be here today. For those on the Zoom, I'm up here in New Jersey, northern New Jersey. Grew up in New York and then been out in New Jersey with my wife and 4 kids that are now ages 19 to 26. So we have a bit of snow up here, the remnants of a storm from last week. And so I wish I was in probably much warmer Texas, I imagine, Hull.
It is. It's 65 degrees here today in Austin, and unfortunately, we're going to get winter weather Thursday. And
Wow.
this time last year, we had 9-degree weather for a week and a half with snow on the ground the entire time. So people are really hunkering down for another one of those. Although I doubt this will be the same as last year, where the power grid goes down. So we're hopefully hopeful about this one. But well, thanks for telling us about yourself. Can you tell us a little about Polsinelli and about your practice there with intellectual property? What does it cover, and what do you spend your time on?
Sure. So Polsinelli is a law firm with 900 plus attorneys in 21 U.S. offices. They are a general practice law firm. So that means that for a lot of startups that I work with, we bring them in, we do corporate, we do the venture capital work when we're raising money from friends and family rounds, seed rounds, Series A, B, and C, and family offices and a lot of group. For today's discussion, out of the 900 plus attorneys, we have about 165 in the intellectual property group all over the country, with the main office being in Kansas City. So the nice thing for me is, I've been practicing for almost 25 years. Going back to many years ago, I started just getting patents in a boutique firm in Midtown Manhattan. Then I went to a major law firm for about 11 years, and I did a lot of M&A litigation, more of a patent prosecution guy, but I did plenty of post-grant work and re-exam work. And then I've done a lot with the patent office. Served on a 9-member advisory committee for 6 years, 2 3-year terms. I've done president of a 1,000-member IP Law Association in New York. So I've done a lot with the government and the patent system and work with the Senate and House on IP issues. So going back to Polsinelli, the real thing I love about it is we're a general practice firm. So as much as we're going to focus today on patents and intellectual property, I've seen all aspects of that, but it's quite common for me to work with startups in particular on the corporate side, setting up LLC or C Corps in Delaware, doing cap tables, getting funding in, and handling all the other legal issues, employment matters, and other things that we need to work on. So it's much more than just getting patents. We have to deal with a lot of issues, employment agreements, as I mentioned. So at a general practice law firm, we're not a patent boutique. Some may hear that where all they do is patents. At a general practice law firm, we can handle everything. And I bring in teams of people to do that, including, the life sciences and biotech. You need FDA support too. So let me stop there. Does that kind of give you an overview of Polsinelli? We do have 2 offices, we have 2 offices in Texas, one in Houston, one in Dallas. And then we have our annual meeting in June this year. It's actually going to be in Austin. So Paul, I think you're in Austin, so I'll make sure that I look you up when I come down there.
Great. Yeah. So before we get to our questions, and we do have some coming in already, is I mentioned earlier, in my perspective in helping raise funding, is that half the value of the patents are for investors. And so I always encourage startups to do any patent or intellectual property work before we go out for the fundraise, not after. I find people want to delay that, but that's probably not a good strategy. But tell me more about what you see as the value of patents in a startup or intellectual property more broadly, in addition to fundraising.
Yeah, I think that's a critical point that you mentioned. Having done this my entire career, I've been able to see the business aspect of it. I work with a significant amount of family office investors. I work with 30 or 40 active startups at all different stages. So I get to see it from all sides. Investors will hire me and say, Pete, can you look at this startup? We're looking at putting $1 million, $5 million, $10 million or more money into it. Can you tell me about their IP? So initially, the value of patents is that working with so many investors and family offices and strategic partners, most big companies have venture capital groups that invest in startups, is the investors want to see the intellectual property. They want to see a patent, they want to see some branding, and they want to see some trademarks. If you're dealing more with the software side, you want to also have some copyrights in place and so on. So it's very important because you always want to please the investors. I probably look at several pitch decks a week, and if not, I've, over my career, looked at hundreds and hundreds of them. The investor deck normally has at least one, if not two slides in there about the patent portfolio, the intellectual property strategy. Those are things I look at when I'm buying companies or working with clients to invest or acquiring companies. And those are things when I work with the startups that we put in there. And we can go into more detail in the strategy, but especially at the early stage, this may be controversial, you're not really looking at your patents to block others because you don't have the money to get into big litigations and so on. You're really looking at it to get some patents to appease the investors, help grow the company. As you expand your portfolio in years to come, then you can look at it more from a patent infringement standpoint. You really get that IP wrapped up in the beginning to appease the investors, and at least in a perfect world, make the argument that you have the patent protection to exclude others from the marketplace.
Great. And so our first question is, how exhaustive is the database at patents.google.com? There are many online resources. How complete do you think those are, and what's the value of those?
Yeah, so that's a great question. They're very comprehensive. When we do searches, we normally have, I think even just today, in relation to that question, the Patent Office announced a new patent search tool. So they're very good, but because of the amount of information that's just going around on the internet and in the world and other patent offices, nothing is foolproof. But I do think they are very helpful, whether it's the Google database, whether it's the West search library at the Patent Office, that searches I work with over the years say it's very comprehensive. So they're very good. I'd use them, but they're not perfect by any means. The other thing to keep in mind with that question is if someone retains me and says, Pete, we got an idea, just to make an example, immuno-oncology, new developments, can you do a patent search or patentability search? We can't tell. All patent applications basically get published 18 months after initial filing. If you get expedited review for a patent application, it may issue, and we can come back to that before the 18 months. But generally, any patent search, any Google search, any search that you do may not capture something that was filed less than 18 months ago, but not captured. So what we try to do, especially for someone with a sizable budget and a very important development, we will do a search, and then we will update the search at least monthly, if not more, depending on what the client wants. The other thing to keep in mind is all patents issue on Tuesdays. and then all patent applications publish on Thursdays. So those are the days we try to do updates at the end of the day so that we get the latest information on that. So in short, they're very helpful. I recommend that you use them, but they're not perfect by any means, just because of the significant amount of information out there on the web and all the databases.
Great. So the next question is, if I think I have a patentable software feature, who should I talk to regarding whether it is patentable and what's the value of the patent? How do you coach people on how to make those decisions?
So another great question. What I'll say is in the technology and in the arts, the patent office is broken down into what they call group art units, and each group art unit has a particular focus. So in the software area, it's a much different area. It's much more difficult to get a patent. For those of you that are more experienced, such as Hall on this Zoom, there is some Supreme Court cases going back to the famous cases, the Alice decision. So that basically said, if there's an abstract area of art, then there's less of a possibility to get a patent on it. So specifically for software, which we can define very broadly as cybersecurity, as quantum computing, as AI technology, what the patent office has done to try to clear up or to provide as much clarity as they can is they actually have what we call Section 101, because that's the section of the statute that deals with what's patentable, the patentable subject matter. They actually have groups at the patent office that try to help the public by providing examples of situations or technology in the software and other areas that would be considered patentable. It is not a perfect system, but it is a good, it does provide a helpful guide for those in the space to try to get a better understanding of whether their technology is patentable. So for example, there is a lot out there on cybersecurity. There's a lot of companies in that space getting patents on that. So that would be something that, the examples would be very helpful. And the last thing I'd say, when I was a member of the Patent Public Advisory Committee, we worked on those examples. And the Patent Office is actually very helpful at trying to help practitioners and entrepreneurs and others understand what that is. Again, it's not foolproof, because at the end of the day, you have to go through the courts, the district courts, the Court of Appeals for the Federal Circuit, and even the US Supreme Court has weighed in on what this patentable subject matter is. So, last thing I'd say is, going back a couple of years ago when we worked with the Senate, there was several days of proceedings in the Senate talking about this very topic. What is patentable? And you had people from the biotech community, you had people from the high-tech community, you had many people discussing what is patentable subject matter. There was a push to change the law and never got put into law, but it's a subject that's not easy to answer. And we would do a patentability review, we would look at the examples, and it's something that comes up every day. Great.
Next question is, can you sell patent rights in a case to another party? And can you maybe describe how that process works?
So the answer is yes. It's done all the time. And what we do is part of the group that we have is, the common area is called patent prosecution. It's getting the patents. We have a patent litigation group, then we have a PTAB group or re-exam group that invalidates patents at the office. And then we have a licensing and technology group. And what that does is you would provide to us a list of your patents in the US and around the world, and a list of the pending patent applications. And then there's groups of companies and other groups out there that you specifically hire to license your IP. And what they do is they shop it around to companies in the area. So it's a very common thing. As a license, it's quite common. Most companies want to get exclusive license to the patents, to the intellectual property. and then it's all a contract. It's all subject to negotiation. As a patent owner, or the company that owns the IP rights that I want to license, what I'm looking for is to get a lump sum and a certain royalty payments. What I'd say there as we work on that, a lot of companies or a lot of inventors come to me with a patent portfolio and say, Pete, can you license my IP? And we do try to shop it around and so on, but what I try to remind them is smaller businesses, medium-sized and larger companies, it's easier to license portfolio if you can see a competitor company in the marketplace that's active in the area, and you have an improvement to the technology, but you also have a business plan behind what you're doing, so that we can say you're making $1 million a year from this intellectual property and from the products that this intellectual property covers. And then when you do the license of the IP, what you're doing is bringing a medium-sized or larger global company to help you scale up that IP, where they have an accepted and established distribution, marketing system, and manufacturing system. So you can clearly license the IP. There's lots of money involved in that. There's lots of stories involved in that. And it's a very common thing to do that. I think you're on mute, Hall. I'm sorry, can you?
Sorry about that. Please talk about the pros and cons about using open source code.
So the pros and cons, so there's a lot of things to say on that. The open source code, you mean specifically as far as using it to get a patent. If it's open source, then the fact that it's open source, it's available to the public, and you're not going to look at getting a patent on that because it's prior art. If you use that code in a system or technology to a method of making, method of using, a method of doing something, then you can probably, then the likelihood of getting a patent on the method, on the process, and so on is much better. And then how that code is associated with algorithms and so on. We normally don't like to put the code and the source code, the object code, the algorithm into patent applications, because understand that a US patent is only good from a territorial standpoint in the United States. There's a lot of countries that we all know of that kind of scour through our published applications and patents and try to identify the source code, the object code, the algorithms to try to use in their technology. So, I don't know if I answered your question there, but whenever we try to do things, I chair the med device group, but I get involved in all different areas of technology. We try to get the patent, but we also have to be cognizant that it's territorial and that other countries may try to use that technology. So we have to do a certain balancing act. I don't know if I answered your question on that, but it's with the open source and there's IBM, a lot of companies, or that it can present certain challenges.
Okay. So the next question, and we have 4 more after it, is how often do you have clients want you to engage to challenge the validity of a patent? How often do you see that coming up?
So it does come up. There's groups around the patent office down in DC that just get engaged, and their whole business proposition is on validating patents. In Texas, many of you may know of this gentleman, a great guy. Name is Josh Malone. He's an active leader in the Independent Inventors Association. That one of his biggest complaints over the years was, especially for entrepreneurs and independent inventors, there is industries out there that will get hired and retained to try to invalidate larger companies' patents, independent inventors' patents, and everyone's patents. And going back to a law that was put in place in September of 2011, there's been a lot of controversy about the ability to invalidate patents. Me personally, we have a group that does that. It's more common for a bigger law firm. The way it works is that if we are a defendant in a lawsuit, if our client is defending a lawsuit, we will claim non-infringement, meaning that our product, our system, our process does not include one or more features as required by the claims to literally infringe, or by what we call doctrine of equivalence, infringe the patent. So that's one argument. The second argument is because of all that prior art that we talked about that's out there on the internet and out there in the universe, we always say the examiner gets about 18 to 30 hours, depending on the group art unit that they're in, to do a search to see if a patent should be issued. There is industries out there that will invalidate the patent. We can hire them, or we could do our own separate search. Or normally clients are aware of prior art that was not available to the examiner. So if we get that art, you could either do a re-examination or what's called the Pct proceeding. That's a proceeding before the Patent Trial and Appeal Board to invalidate a patent. So it's a very common practice. Our firm does it. Almost any reasonable law firm will, patent law firm or law firm with a patent group will do that. It's part of the practice, very controversial. And we could have a whole discussion just on PTAB practice and invalidating patent. But for today's purposes, it happens all the time.
Great. Next question is, please explain the difference between a patent agent and a patent attorney. And does your firm employ both?
Yeah, so in short, a patent agent is an individual that doesn't have a legal license, did not go to law school. So that's the short version. We have, out of the 165 individuals in our group, scientific advisors, and we also have patent agents. And generally, these individuals are just brilliant. They have PhDs, and they have the technical chops that are really important when you get into some high-level technology discussions. And they're very intricate. And again, I chair the med device group, and we're working lots of biotech technology. So out of the 165 people, we probably have 30, 40 people with PhDs. And I personally use a number of patent agents. Since Polsinelli's main offices in Kansas City, but we also have offices in St. Louis and throughout the Midwest, we can use those at much more reasonable rates. So say a patent agent will come in, depending on their years of experience, at $400 an hour, as compared to me, a partner in the New York office, that's, I'm coming in at $800 to $900 an hour. So we use patent agents to work with clients on the technical review of the subject matter. They also have significant experience, meaning on the patent side, that they can prepare draft claims, draft patent applications, and submit them to the patent office under my direction, of course. And they have the technical background needed to get what we call a registration number at the patent office. So the patent agents are key. It's a great question. I assign them to work with companies, especially on the technical side. Then I work with the clients on establishing the strategy. In the prosecution, of course, I review the claims and everything else. But just today, I got a request for a patent agent in the chemical area. So I referred one of my people that work in the group. I have a PhD in chemistry. I have another gentleman with a PhD that's working on some other technology for me. It's a very common thing, less expensive way to try to get some protection around the IP using a patent agent. They have a technical understanding of the subject matter. So hopefully that answered the question.
Sure. So the next one is, talk a little bit about provisional patents, particularly regarding software programs and capabilities. What's your take on provisionals?
So provisionals is something that we use almost every day, every week, and it's especially good for entrepreneurs, startups, and even large companies do it. Again, I'm not sure how everyone can see me on this on the Zoom. I have a certain amount of gray hair, and I've done, as I mentioned, a lot of work at the patent office. This is a more background, but so going back to March 16, 2013, the U.S. patent system changed to what we call first inventor to file. Before that, it was first to conceive. So there used to be a lot of arguments over who conceived of the invention first. Going back to that date, any applications filed on or after that date, first inventor to file. So that just raised the importance of a provisional filing. If Hall and I have an invention, it's the same area, same technology, same everything, and he's going to be much faster to me. With a provisional, if Hall filed it first, he would have priority rights to that invention. It wouldn't be any issue really, for the most part, of conception and reduction to practice. Same invention, same everything. We would file a provisional, you would get priority rights. If I filed a week later, 2 weeks later, and that would eventually come out in litigation or later on when the application will get published, that heightened the importance of the need for provisional patent applications. So going back to the question, what is a provisional application? It is a date that you get when you file, electronically file normally, a patent application in the patent office that gets you patent pending. So a client will come to us, say, Pete, we're doing this presentation tomorrow. We know we didn't file anything. What can we do today? We say, send us it. We're going to do paperclip provisional patent application, and we're going to get you a patent pending status in the IP, meaning that you have filed that invention in the patent office to get it. It has what we call a 1-year term, to the extent that it gives you 1 year to determine if you have commercial viability of the subject matter included in that provisional. So the reason why that's important is because that 1 year, you can shop it to investors, you can shop it to strategic partners, you can put it out there with the patent pending proprietary subject matter title, a hashtag, whatever you want to call it, and that lets investors, strategic partners, and others know that you are smart enough to get a patent on file. Now, there is the downside of provisionals is that although you do get patent pending, you only get that for the subject matter that you put in the submission. So what we normally end up doing is supplementing that submission either a month after filing, 3 months, 6 months, anything after, and we try to capture everything within that 1 year period in a non-provisional that we file 1 year later. So it's very important to get it. And also from a money standpoint, it's $150 patent office fee. Most firms, my secretary or paralegal of 18 years, Hannah, will just handle that. And it's like a $200 charge. Most firms have a fixed fee charge, like $1,000 or whatever to handle that. And it's relatively inexpensive. So clients will come to us and say, Pete, can we just do this? If the meeting next week turns out important, then we'll spend more money and do a patentability and review on. But it's something that provisionals are very, very important. Entrepreneurs and others do it. And there's, we do it all the time.
Great. Next question is, how enforceable are international patents? Applying to all developed countries is rather expensive. Are some countries more valuable than others due to enforceability?
Yeah, so it's another great question. And it's something that probably deal with several times a week, especially with smaller companies, just because it gets expensive. And what I say is that any money that you provide is for the most part going to foreign patent offices and foreign patent agents, and it's not going. And if any translation is needed in Brazil, Portuguese, and then China, of course, for Chinese, and Japan, you need Japanese translations. So it gets expensive. For smaller, it's very hard to enforce it in China and other countries. So what we normally do is if you file a patent application today, 1 year from now, not only is the 1 year requirement for the provisional to file in the US going to come up, but then there's also what we call Pct International Application. That PCT, it gets a little confusing, but you file it at a 1-year date. That reserves the right for you to file in other countries 18 months later. So that gives you the right to file in those countries, Japan, China, Australia, and 150 different countries. So the reason why I say all this is you have, in essence, 30 months to decide whether you want to file in these international countries. If you show during that 30 months from filing to enter the national stage that there's commercial viability, and you have a license agreement, you have a relationship with a strategic partner, you have an investor with deep pockets, they're going to generally want you to file in China, in the EPO, in Europe, just to have the right to later enforce it in those countries. So then what happens is you get patents in those countries, and then you try to get more than just one patent, just like in the US, and you have to enforce it. But it all depends on your pocketbook. If you're in a biotech area and you license the technology to a pharmaceutical patent, they're going to want you to get the patents internationally, and your valuation will increase. So it's helpful. The difficult thing is when you work with universities, when you work with hospital systems, when you work with spinouts, in those early days, the 30-month period, it gets to be very expensive. So I'm working with a doctor right now on this exact issue. And, the filing is coming up in a few weeks. He's looking at $30,000 or $40,000 to file in these countries. So this is even before considering any enforcement opportunity. The likelihood of enforcing is very, very tough, but you want to, again, consider filing there to so that you have the option, because all of that will increase the valuation, and then you can file. So my answer to your question will focus more on the prosecution side, because you can't get to the enforcement side until you prosecute. But I'm a big basketball fan. If you ever want to check out the NBA and what Michael Jordan had to do to enforce his trademark rights in China, he has the money, he can do that, and it was quite the challenge. Companies like Nike and others have challenges in doing that. So it's very difficult. There is plenty of law firms in China that I work with that are very good law firms, but there is, you can appreciate that if there is a case against a Chinese company in China, just like if there's a case against a U.S. company in the U.S., there's certain benefits to the home court advantage that make it very difficult. So unless you're in license or you sold your rights to these, a company with much deeper pockets, it's going to be very difficult unless you have the financial backing to enforce it. And again, I can talk to you for a whole separate. We've done a lot of work with DOPR, with the FBI, with the federal government. The team has probably read about rights in China and IP theft issues for China. With all respect, there's a lot of discussion about that, and it's a $5 trillion issue, trillion with a T, and everyone's involved. It's a difficult issue to enforce. What I'd say, to short answer your question, deep pockets. Plenty of big companies do it. Some successful, some not. It's a very difficult issue to deal with.
Great. So you answered our next question, which is, how do you enforce cases of Chinese breaches of a patent? And the answer is with a lot of money and a lot of time, and it sounds like it may not win altogether. So I think we covered that one.
Yeah. Let me jump in with one point, because we've done a lot of work with the government and others on this issue based on the work I've done in Washington, the patent office. So generally, the patent office is very good. They're in the Commerce Department. They're under the Commerce Department. So what I'd say is they have branches of the U.S. Patent Office, and there's individuals that are actually stationed around the world, several of which are located in China, India, Brazil, Europe, throughout Mexico, throughout the world. And if anyone needs information, there's information about that there, and they provide resources to help you with particular challenges in China. But again, high level, it's very difficult.
The next one is, I've been working with a chemical engineer agent on provisionals. It's a lower cost for now. I'm a PhD chemist myself. Maybe we could talk sometime. What does it take to become a patent agent at a Polsinelli firm?
So you just, you have the background. We have the PhD. It's a great start. And then if you go on the uspto.gov website, and there's information there about taking the patent bar exam. And then you take the exam. It's a very difficult exam. It's about patent procedure. And there's a number of courses. I taught many years ago through Barbary, a course on the preparation for taking the patent bar exam. So that's what you in essence have to take. And that individual with the chemical background with the PhD would have the technical background to take the exam. And then there's great programs, this gentleman John White and Gene Quinn and others. They have a PLI, patent bar review course. They're great people, and they try to help you prepare to take the exam. It's like anything else. It's a difficult exam, but if you take that, you become a patent agent. Then Polsinelli would love to have you, and other firms would love to have you, because my background is mechanical engineering. So it's just I try to review a lot of things, but you can appreciate with the vaccine technology in and of itself, the mRNA technology, other things in chemical bonds and the chemical issues, they are difficult areas, and there's a lot of stuff going on there. And then, so it's a great area. People do very well there. And, I recommend you do it. And Hall, feel free to share my information with them, because it's a great area that not enough engineers and technical people know about.
Right. Next question is, international patents, would they be valuable for licensing to a big company, say 3M? In other words, if you had an international patent, do you think that would really make your case to have a good licensing strategy?
The answer is yes. Yeah, generally the answer is yes. 3M, gentleman Kevin, he's very active in the U.S. government and testified in front of Congress and many others. It's like, intellectual property gets confusing sometimes, but if you associate it with real property, if I have, a house in United States and Italy and Australia, and I'm going to sell it, it's going to be more valuable, right? So if I have intellectual property rights, patents in Europe, in Australia, in India, and in China, the intangible asset is going to be more valuable. Now, the bigger companies in particular, whether it's J&J, whether it's 3M or others, they're going to be fully aware of the challenges in those different systems. But it does help. It does help that you get some IP protection there. And there's an argument for increased valuation. So that's why those arguments, the numbers may be much more significant. So that's why I do recommend filing a PCT, which has a cost of $3,000 to $5,000 to at least reserve your right to file in these international countries 18 months later. When you get to that 30-month mark, if you don't have the money, then you can't enter all the countries. But at least I recommend that people file the PCT, because if you do eventually get patents internationally, then, as you said, the value proposition will increase, because the intangible assets, the asset pool will be increased as well.
Great. Next question is, give us the best practices to protect, foreign patent rights.
Well, hire a good reputable law firm. So it always helps. We do a lot of work in Canada. So Osler, I'll give them a shout out. OSLER is a very good firm. There's other very good firms that we work with in Canada. We work very closely with them. So, the first thing I'd say is getting a good team on board to do that. And the same thing for the EPO. For a very important subject matter, we before we enter the national stage, or even before we do a filing, if we know that 30 months later we're going to be filing for patent protection in the EPO for a big client that's a multi-billion-dollar subject matter, we will sometimes bring in foreign counsel very early on, because each patent system is different. So some technology, the 101 area we discussed before, what's patentable subject matter, we would bring, certain countries would be able to get patent protection in Europe and in China and in Australia and India, in areas that very controversial, we would not be able to get patent protection in the US. So we have to look out 30 months and say, here's our disclosure. For us to adequately protect the intellectual property, not only in the United States, but around the world, we need to bring them in sooner rather than later. And that's what we do. Again, it's all dependent on budgets, and we can't do that for every client. So it gets to be difficult. But to protect internationally, one of the things that we try to do is really get them engaged sooner rather than later. I consider myself an expert in the patent system in the United States, but I'm fully aware that the laws, the legal precedent, and so on is much different internationally than it is in the United States. So we need to bring in that expertise sooner rather than later. So that's what we try to do.
Great. Well, if anybody else has a question, please go ahead and post it. My last question for this session is the following. I've often heard patent attorneys express the desire that we should start with trade secrets wherever we can, and then move to patents wherever trade secrets fall short. What's your coaching there, and where's the line between a trade secret and when do you go to a patent?
So another great question. And there's lots of stories there. So let's go back to the basics, right? What is a patent? Patent is a intellectual property right, intangible property right, that allows a person with a patent in the United States to exclude someone from making, using, selling that claimed invention in the United States. And also, because everyone wants the US market, we'll work with US Customs to prevent someone from importing that infringing product into the United States, whether it's inkjet printing device or anything like that. So even if something is manufactured internationally, they try to bring it into the US. We use a US patent to stop that, right? So the trade secret stuff, again, a lot depends on the budget. The most famous example of a trade secret is the Coca-Cola formula. It's never been patented. It's not disclosed to the public. It's a trade secret. With a trade secret, what I've discussed with the Senate and the House and the staff and others, you can't take that trade secret and bring it into a federal court and say, we have a trade secret on that, I want to exclude them. You can't do that. So how do you protect a trade secret? It normally comes up in the software environment, and we normally start there. What I'd say though is we recommend, just from the standpoint of provisionals. Provisionals, the other advantage I may not have mentioned before, if you don't pursue them, they do not get published. So, we normally would file a provisional as well. I don't know if I'm answering the question too well here. It gets to be difficult. It gets to, based on the budgets, what you want a trade secret. I can tell you that the challenge with a trade secret is that in certain crowded areas of art, if you keep something trade secret, you don't document your invention, you don't do what we call defensive publication, if you don't do anything like that, then there is a possibility that someone else in a crowded area of art may file for a patent application, may claim first inventor to file, and if you don't have anything publicly available or prior art, you can invalidate the patent, and they're going to get a patent on it, even though you were the first one to invent. So, you know, it gets to be a difficult issue. Some companies don't have the money, and others don't want to disclose it. So we do the trade secret approach, but there's risk involved in that. And it's an issue that comes up quite often. You know, to give you another example, we will sometimes get a patent on the device or the composition for a drug, but we will not really get a patent on the method of making, the method of using, and so on, because we want to keep certain information trade secret, where we'll get the protective features for the device, the apparatus, the composition, but the method of making it's, you know, in all the algorithms, it's easier for competitors to steal that information. So it's not a conversation that we can have in 5 minutes. We normally give the pros and cons of that and the risk of doing so. So it's a good question. We, you know, in short, we use trade secret more for software because even if you get a patent in the software area, more difficult to enforce based on Supreme Court precedent and other things. But it's something that we're always focused on because going back to investors, I think they're more inclined, depending on the technology, to want to see some patent applications filed.
Great. And one last question from the audience, and then we'll wrap for the day. The question is, it is my understanding that if I make a non-confidential disclosure of an invention in the U.S., that I still have a year to file on in the U.S., but that I may lose my foreign patent rights due to a lack of an NDA. Is this correct?
In short, it's correct. Yeah. So we always worry about that, it comes up. So yes, and that's why going back to the benefits of provisionals, is that we'll try to get a provisional on file rather than having this disclosure, not just for the U.S., but also for internationally. And it's subject of a lot of debate over the years on the grace period in other countries, but it's called grace period, and it's related to the subject matter of the technology. It gives you, you know, a certain amount of 1 year to, if you know, experimenting with the technology and it's inadvertently disclosed, you do get that. You know, we still like to use the provisionals and get something on file so that if something's going to be published tomorrow, we take that publication and we file it in provisional today so that we preserve our protection in the United States and internationally as well. So the other thing I'd say is generally that's correct, but, you know, depending on the country, we would also still try in all the countries, but generally, especially in Europe, it's very difficult. So the only thing I want to add one separate topic altogether about pricing, because that always comes up, especially for startups. And then quick thing on expedited review. Provisionals we discussed, relatively inexpensive. The other thing is expedited review. If one of the inventors of the list of inventors is 65 or older, you can get expedited review based on age. You just got to show a copy of someone's license or some other things. And that is really great. That means the application is getting examined in a period of really 3 months, 4 months after filing. The reason I say that is investors don't fully appreciate the difference in scope of claims, but they do know the difference between a provisional application, a non-provisional application, and a patent and a PCT. Claim interpretation, claim scope is much more difficult. So the reason I say that expedited review is very good. If one of the inventors is not 65 or older, then the patent office has a program called Track 1 Expedited Review that you pay if you're a small inventor, a small, what we call a small entity, less than 500 employees. You pay $2,000 to jump to the front of the line. And that's very helpful for investors and so on. Just something to keep in mind. Patent Office years ago, in an effort to work with independent inventors and the really novices, they also have what they call a micro entity. There are certain requirements of that, salary and other things, that less than 4 applications. We try to stay away from that. We've used it a few times. Of course, it's actually 25% of the fee. So micro entity, you'd only have to pay $1,000 to get expedited review. But so anyway, so in general, check out expedited review, use provisionals, and then Hall. We covered a lot of topics today, but feel free to reach out or give my contact information if any wanted. From an investor standpoint, Hall, I know you see it from all areas. Did that capture a lot of what you see in the IP area too, or the international stuff is always hard?
Yes, the investors are very interested to see patents in these deals because it shows some additional value that comes into it. We may not be able to fight off Google in a patent fight, but there is value to have some intellectual property in the deal. Shows a little bit more gravitas behind the technology too. And at the same time, the world's becoming more global. So international patent starts to become a bigger issue than it was, say 10 years ago, where it really wasn't a care about at all. But now it's becoming a bigger deal. So as the world gets more global and more interconnected, it does become a bigger factor for people as well. But appreciate your taking time today, Pete, and sharing that great information with us. I want to thank our audience for all the good questions and what you guys are doing there. We'll make introductions afterwards so you guys can continue the discussion and dialogue after the event's over. I appreciate you guys joining today. And with Pete, let's stay in touch and appreciate the work that you're doing there.
Yeah, thank you very much. Well, enjoyed the discussion, and for those in the audience, thanks for the questions. I think the questions really covered something that we discuss every day with clients and very relevant. So happy to help and thank you again, All. It was great.
Great. Thank you, guys. We're going to close it now and see you next time. Have a good one.
Yeah, thanks, All.
Bye.
See you.